Hello, welcome everyone. Thanks for being here today. I'm Charlotte Gibson, president of the Charlottesville chapter of the National Organization for Women. And with me today is Lisa Sales, president of Virginia Now. Thank you for joining us on Constitution Day, the day we commemorate the signing in 1787 of the US Constitution, the foundation document for our laws. One huge flaw, still uncorrected today, was that it did not provide equal protection for half of our population. But over time, Supreme Court decisions have secured rights not explicit in the original Constitution. Today, we're delving into the loss of one of those rights, our constitutional right to have abortions, recently revoked by the Supreme Court in Dobbs versus Jackson's Women's Health. We're fortunate and excited to have two brilliant university professors, Ann Coughlin and Bonnie Gordon, to break it down for us today. As we allow a few minutes for folks to join, we'll share a little about Now. Lisa?
Great. Thanks, Charlotte, so much. Hi, everyone. Good to be with you all today. Thank you for joining us. I wanted to share with you the mission of Now. Now's purpose is to eliminate discrimination and to achieve and protect the equal rights of all women and girls in all aspects of social, political, and economic life. And Now's 6 core issues since its founding in 1966 are economic justice, reproductive rights, racial justice, LGBTQIA+ rights, constitutional equality, hello ERA, and ending violence against women. If you're not already a member of Now, we urge you to join us. There is strength in numbers and your support really matters. And when we lift our voices together, we are certainly more powerful than we are as individuals. So you'll find links in the chat to become a member. The Now chapters in Virginia are all volunteer. That is solely driven by volunteer work. So email us to learn more or go to our website, vanow.org, and learn how you can get involved. And for additional information on our upcoming projects. So echoing Charlotte, we're so honored to have with us University of Virginia professors Ann Coughlin and Bonnie Gordon. And so a little bit more about both. Ann Coughlin is the Lewis F. Powell Jr. Professor of Law at UVA. She previously taught at Vanderbilt Law School, joining the UVA faculty in 1996. Her primary research and teaching interests are in the areas of criminal law, criminal procedure, feminist jurisprudence, and law and humanities. She co-authored a casebook on criminal law and has written articles exploring the intersections among criminal law, criminal procedure, and feminist theory, as well as essays connecting law to literature. In 1999, she received an All-University Teaching Award, one of the university's highest honors for excellence in teaching, research, and service. She led the Molly Pitcher Project, which challenged the ban on women in military combat and may have contributed to its demise, thankfully. She has served as co-chair of the National Association of Women Lawyers Supreme Court Evaluation Committee and of its Amicus Committee. Coughlin received her JD from New York University School of Law, where she's won numerous awards and served as managing editor of the NYU Law Review. After graduation, she clerked for Judge John O. Newman of the U.S. Court of Appeals for the Second Circuit and for U.S. Supreme Court Justice Lewis F. Powell Jr. And Bonnie Gordon is a music historian who works across disciplines and creative practices. She's an associate professor, College of Arts and Sciences at the Department of Music at the University of Virginia. Dr. Gordon plays jazz, rock, and classical viola, so she is also a musician, and is fascinated by the idea of sound as fundamental to the ways we move through the world, and is deeply committed to the idea that learning about sound is not for musicians only. Her research centers on sound and gender in the early modern world. In addition to her scholarly work, she has published in the New York Times, the Washington Post, and the Seville Weekly, as well as Slate. Her book projects include Jefferson's Ear, which closely explores the historical record, especially what is and is not in Jefferson's music collection. The silences in the written record resound with the racial fear and exclusion that were as much a part of the American Revolution as inalienable rights. And musical aesthetics matter deeply in the emergence of race as a political and social category. Dr. Gordon is a founding faculty member of the Equity Center and founded the Arts Mentors, a program designed to increase access to the arts in Charlottesville. Both Coughlin and Gordon work together as directors of UVA's New Sound Justice Lab. It's a space for exploring creative and everyday responses to legal failures and erasures. What happens to our law and to our democracy when judges, politicians, and other powerful institutions ignore the voices of women, people of color, LGBTQIA+ folks, and Indigenous people? It's a really critical question, and we're working on that now as well. When judges and politicians silence the voices of women, girls, and other marginalized individuals and groups, where do those voices go? The Sound Justice Lab uses research, advocacy, and creative practice to amplify and to support the voices often omitted by formal legal processes. And so Anne does not know this yet. And speaking specifically of legal failures and erasures, she's been on my list since springtime to call about our new signature project. And now I know I need to speak to Bonnie too. Our new statewide project is called the VLAP, VLAP, and it stands for the Virginia Law Audit Project. What's the purpose of that? It's to do a modernization review to make sure that we void out any forms of discrimination in our state constitution, in our general laws, and in our administrative code. So we're going to be doing a deep dive, first step, what I'm calling the lighter lift, to root out non-gender neutral terms and make them recommend to the General Assembly that we use gender neutral terms throughout all of our statutes, laws, policies, et cetera. And we're also going to look to identify all forms of discrimination in these documents as well. So with that said, thank you, Professors Coughlin and Gordon, for being here with us today to talk about the Dobbs decision. Over to you both.
Thanks, Lisa. Thanks, Charlotte. And thanks to all of you so much for being here. It's really wonderful of you to invite us to speak to you about this important case and give us the chance to join with you in community and to hear what your questions and your thoughts are. As Lisa mentioned, today is Constitution Day, or perhaps Charlotte mentioned it too. And I've been reflecting on the significance of Constitution Day and this conversation that we're having. And I think it's fair to say, at least for me, I'm not here to celebrate so much as to mark the occasion by thinking critically about this case. It's enormous constitutional magnitude when the United States Supreme Court decides to withdraw a constitutionally protected liberty interest. And of course, that's precisely what the Dobbs decision does. By overruling Roe and Planned Parenthood v. Casey, the court has removed from women and other people who are or may become pregnant the ability to seek abortion care, the right to seek abortion care. So this is a very big deal. Constitution Day, I take it, is always very important, but I think that this particular term with Dobbs and alas, some other decisions, we're seeing a really important phase of our constitutional lawmaking by the Supreme Court, and it'll be interesting to see where we go from here. So I know I speak for Bonnie when I say that we're delighted to be here, and we're going to jump right into it. Thank you for those incredibly generous introductions, and we are especially pleased to have you highlight our work with the Sound Justice Lab. And we are hoping to be able to continue the conversation today with all of you and your cohorts, your mates friends and family, so that we can decide what we all should be doing together, particularly here in Virginia. And that's why I'm also delighted to hear and be involved with your new signature program. I have a lot of thoughts. I will stop, but I may mention them some of them as we move forward. So I just thought I would show you that. I don't know how many of you have read Dobbs, but it's, you know, this is it. This is single-sided, so it's not quite as bad as it looks. But it's a big monster read, and we think that it's important to spend some time just thinking about the case itself and about the constitutional analysis, the constitutional reasoning that led a majority of the Supreme Court in 2022 to decide to withdraw a constitutional liberty interest from women. And again, you know, I haven't double checked this, but it's a very, very rare occasion on which the court does that. The court, yes, the court overrules cases, but it does not do that when those cases articulate a constitutional right. And in fact, those cases have been upheld repeatedly. So this is a very big deal. And it's important, I think, to understand the case. I don't know how many of you are lawyers, and maybe a lot of you have already read parts of the case. I know certainly you've read about it. It took me a while to read it. My heart was so heavy, I just couldn't bring myself to look at the language that revoked our rights. But we think it's really important because almost every time I go out, there are a lot of people in the world, including, you know, really well-educated people who are law adjacent, who think that if the Supreme Court says that a law is unconstitutional, well, then that law is unconstitutional. And if the court says so, it must be so. And people often feel disequipped to think critically about what the court did, and also to actively criticize and to talk to other people, to push back when people say, well, it's got to be so because the United States Supreme Court declared it to be so. And so our agenda is to talk to you a bit, and these are conversations that we're already having here at the law school with our students. I spent some time with my first year criminal law students on the implications of Dobbs for cases such as Lawrence versus Texas, which forbids the states to punish people for having gay sex. You know, what's going to happen now that Dobbs is in place? What's going to happen to Lawrence? That's another criminal law area. And of course, the students are very unsophisticated at this point. A lot of folks wonder, why is Ann Coughlin teaching Dobbs in her criminal law class? That's something that they should be doing next semester in constitutional law. But I think not. I think it's really important to point out to them the implications of this case for so many parts of our law, including criminal law. Because of course, that's precisely what Dobbs does, is it gives the states the option to criminalize the seeking, the obtaining, the provision of abortion care. And so I feel like my field, criminal law, is directly implicated. So we're going to talk to you about the case in ways that we talk to our law students, in ways that we talk to each other. It takes many readings to figure out what a case really means, and we need to do that in community. So the first thing that I wanted to do is to just talk to you briefly about the constitutional text that's at stake in the Dobbs decision, and give you just a little bit of background in how the court has approached the meaning of that text, so that you can think through the work that the court does. And of course, the constitutional language is contained in the 14th Amendment to the United States Constitution. And the 14th Amendment reads as follows: no state shall deprive any person of life, liberty, or property without due process of law. So no state shall deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So you have both this commitment to preserving liberty without due process and this very important commitment to equal protection right there in the 14th Amendment. And that is the clause that is at stake in the Dobbs decision. The court focuses on whether the phrase, the state may not deprive you of your life, liberty, or property without due process of law. Does the word liberty encompass a protection that means that the states may not deprive women of access to abortion care? Does liberty include a constitutionally protected right to abortion care? So I just want to focus there briefly because it's an interesting part of the debate, and you need to understand one of the stakes here is that the due process clause is understood to and does have two different components. And one of those components is a procedural component. So the idea is the state is allowed in many, many contexts, alas, as we know, to deprive us of our life, liberty, and property. And what the due process clause says is the state may take away your life, liberty, or property, but in order to do that, it has to give you due process, which is understood to be fair procedures. And according to Justice Thomas, in his concurring opinion in Dobbs, he believes that that's all the work that the due process clause does. So in other words, what he says is this is a procedural protection. The state gets to take away your liberty as long as it gives you due process. And it did that here. It gave you procedural due process. So he thinks there's, just not a constitutional issue at all. And we'll get to that question in a bit. The rest of the justices in the majority agree with Justice Thomas. This is mostly a procedural protection. Before they can put you in jail or take away your house under eminent domain, they have to give you a fair hearing. Everybody agrees that that's very important work that the 14th Amendment does. But in the line of cases we're discussing, which includes the contraception cases, the reproductive justice cases, the cases about having sex, there are allusions to one's interest in raising one's children, and so on and so forth. A majority of the court has long recognized that the due process clause provides more than just procedural protection. It also has a substantive component. That is, that liberty has a substantive meaning, and there is a core to liberty that the state may not take away no matter how much process it gives you. We are guaranteed some kind of core liberty that is beyond the power of the state to invade at all. And so that's just to clear up the mystery. Like people go, oh my gosh, what is this substantive due process thing? The students go crazy over it. It feels like, some mysterious inquiry. And it's really quite simple. It's just that there's some stuff that the state can't punish. There are things that you and I and everyone else, we get to decide to do on our own. And even if the state feels like punishing us, it simply can't. So the fight is over that space, if you will. What is the core meaning of liberty? And I take it, I think, well, I don't know if all the justices agree, but including some of the justices in the conservative majority will agree that there is some sort of substantive right there. The question, of course, then becomes, what does liberty mean for these purposes? What do we mean when we use the word liberty in this constitutional sense, when we say that there's something so precious that the state can't invade it no matter what good reasons it gives, no matter how much process it gives? What is that core of liberty? And it's there that the debate is taking place. And it's obviously a substantive debate. It's an ethical and philosophical debate. But it's also a methodological debate. by which I simply mean, how do you decide what a word means? You know, this is something that each and every one of us do all the time. I don't know about you, but I'm sort of obsessed with dictionaries, and I'm constantly looking up words. Like the other day, I couldn't remember what indemnification meant exactly. And I thought, what am I saying this for? You know, I better look it up. So I looked it up, and thank goodness I was using it correctly. But, you know, so that's the lawyer job. You know, I just want to tell you that that's the thing that the lawyers are doing. We have this document, it protects our liberty. States got to stay out of certain stuff. What does liberty mean? And what Justice Alito says in his majority opinion, Justice Alito writes the majority opinion in Dobbs, and he overrules Roe and Casey, eliminating the constitutional protection for abortion. What he says, I mean, I take it most of us would agree, liberty is a capacious word. It's an elastic word. It potentially has many different meanings, and we have to proceed carefully. So, and of course, you can immediately see where he's going with this, so that we as judges don't substitute our own value judgments. You know, it's not right for this group of this little group of 9 to substitute its own value judgment. So we need to be very careful in deciding what liberty means. So that's what the debate is over. And Bonnie is going to talk in a couple of minutes about the sources, the textual sources to which Justice Alito looks, and the damaging work. You know, I think she's prepared to say it is bad history, which we're kind of used to. I mean, lawyers, Supreme Court justices may be learned in the law, but they're not historians, and they look and pick and choose. And lawyers do history all the time, but we do history badly. But in any event, that's what the debate is over. How do you figure out what liberty means? Whose definitions do you look to? What dictionary do you pick up? And so on and so forth. And so here's the move that the Supreme Court majority makes. And this is one that my first year students picked up on pretty quickly. It took a little while to get through the case. But the question is, what does liberty mean? And liberty, whatever it means, does it encompass a right or a protection to seek abortion care, to seek to have access to this kind of reproductive care? And so that's the question. And so I asked the students, you know, well, where do you start? You know, and the place you start, the question that you say, I am bound to answer, obviously is outcome determinative. You know, where do you start? What level of generality? And so the majority in the Dobbs case, led by Justice Alito, really doesn't ask, what does liberty mean? Instead, he just immediately jumps to the question, does the Constitution protect abortion? Does the Constitution mention abortion? And the minute you do that, you can see that the jig is up, right? I mean, of course, the Constitution doesn't mention abortion, and reproductive justice, and the right to contraception, and the right to same-sex marriage. The minute you start at that sort of specific level, you've lost, and you know that. You go, I know what's coming. Okay, so what I focus on the students is that instead the question isn't that. The question is, what does liberty mean? You know, the word liberty is the word we're aiming to construe here. And Justice Alito and those who joined him in overruling Roe, what he says is, first of all, we have to look to see, well, what is the constitutional text? What does the constitutional history have to say about abortion? Instead, that's part of it, but what he also says is, look, liberty extends only to fundamental rights, certain fundamental rights, and they have to be deeply rooted in our nation's history and traditions. And the history and traditions that matter, he says, are the history and traditions that were present at the time of the ratification. So what did liberty mean to the framers and the people in their world? And then he immediately says, would they have understood that people had a right to an abortion. And again, the answer to that question is no. But I just want you to notice how he's pitching the analysis. He doesn't say, what did the framers think liberty means? And the students finally saw that. Like he says, what do they think liberty means? What do they think about abortion? The question is, what did they think liberty means? And who would you read to make that decision? And the students very quickly came up with people that, again, I don't teach common law, thank God. But they very quickly said, people like John Locke. Let's turn to John Locke. Let's turn to a great philosopher at that time and political theorists who are speaking about what liberty means as a more, sort of general conception, or concept. I'm not sure I'm using the right words, but let's really think about this. What were the things, speaking more generally, that people need to flourish? And then from there, reason down and ask, well, does that broad concept, that broad value judgment that there are certain liberties that are essential to being a free, flourishing member of a society, should that encompass this right to reproductive care and so forth? So I just thought, yes, they got it. That's exactly what I think you should do. And I'm not sure where the analysis would go. In the hands of a Justice Alito, we'd probably end up in the same place. But I just want you to see how narrowly they frame the question. And then, of course, what happens, and Bonnie's going to jump in here, I hope, is that what Justice Alito says is the only history and traditions that matter are those at the moment of the framing, the ratification of the 14th Amendment, and before. We have to cut off our exploration of history and tradition at that moment. And what you want to notice again, this is very important, is he's making an extremely important methodological assumption, which is that in construing the Constitution, in construing that word liberty, the people who wrote it wanted us in 2022 to interpret that word by reference to their beliefs, that they thought that the word was static, if you will, that it was frozen in time, and that we were bound forever by the perspectives that they had, on specific issues like gay marriage or contraception. Though I did ask my students about the history of condoms, because I'm wondering, I'm thinking that should be on the radar screen too. If the court really is prepared to say that the Constitution doesn't protect access to contraception, I found myself thinking, I wonder what the history of condoms looks like. But in any event, you can see what I mean. He's making the assumption that for purposes of the Constitution, the framers used the word liberty, and they meant to limit our inquiry to that moment in time. And it's here that the debate takes place between the majority and the dissenters. So Justices Breyer, Sotomayor, and Kagan write a joint dissent. It's very rare. Usually a state author, each justice will author the opinion separately, and then others will join. This, the three wrote together. And what they say, and there's a very powerful tradition in our law that supports their point of view. Many jurists have agreed over the years. Justice Kennedy, for example, who wrote Lawrence versus Texas, who wrote Obergefell, which is the same-sex marriage case. They say, no, wait a minute, you're making a mistake. The question is, what does liberty mean, not what was the history of abortion? And then they point out the framers did not intend for us to be bound to that one historical moment. Instead, they used a capacious word that allows us to look beyond the meaning of liberty at that point, because they knew that times would change. They knew that they didn't understand all of the specific details of what liberty would encompass. They knew they were writing a constitution, and their intention was for it to endure for centuries. And how could it do that work if it was limited to 19th century, or in this case, 13th century views of what people thought about women and liberty? So I just want you to see that that's the move that the that you need to understand. And what you need to understand is that the move that the dissent is making, even though the contemporary majority claims that it's lawless, claims that these are activist judges who are trying to impose their views of policy on the court, you know, Breyer, Sotomayor, and Kagan, good Lord, they're very moderate, even conservative lawyers, that they've somehow run amok, you know, and they're just saddling us with their policy preferences. That's just completely false. They're invoking a very well-established and well-supported approach to deciding what this word liberty means. So that's where the debate falls. You see Justice Alito saying, sorry, guys, you know, we're just doing what we've got to do. We're stuck. We have to look at the history of the ratification. And when we do that, of course, we discover that abortion, the framers would not have thought abortion was lawful. And the dissenters say, we're not limited to looking to those histories, that history and tradition. Instead, we can take a look at the evolving meaning of liberty, which includes the history that led up to Roe v. Wade, many, many decades of very smart judges, including Supreme Court judges, agreed that our history and traditions, including those of this century, support this more capacious reading of liberty. And they then look to more contemporary sources. Again, their definition of liberty is rooted in precedent. They're not just making this up, but they're looking to a different set of historical materials. So that's what the dispute comes down to. Whose dictionary, if you will, should you use? And as Bonnie will tell you, when we rely on the sources that Alito relies on, women and people of color, LGBTQ people, people who had no humanity, weren't recognized as being full human beings, suddenly we're written out of the constitutional dialogue, the constitutional definition of what interests are protected by this word liberty. So now I'm going to turn it over to Bonnie. And I can't see her. I'm sorry. Zoom is great because I get to be with all of you. But
I think we lost.
as you can see, I'm a little inept.
And we lost Bonnie. I think her Wi-Fi service is
okay.
proving troublesome. So, and it looks like we have a question in the chat, but I just wanted to remind folks, we are going to have time for questions. We're going to save them to the end. So sorry, Anne, back over to you.
Yeah, so I'm so sorry to go on and on like this, but I'm going to go on a little bit longer and then we'll open it up for questions. So what Bonnie would say if she was here, and it's incredibly illuminating, she is a musician. She's a really fabulous musician. In fact, that's what she's doing. She's doing a gig and they had promised her that she would be able to Zoom from there, and clearly it's not working. But she's a musician, she is a music historian, she's a feminist, and she knows the history of, she knows medieval history, Renaissance history, early modern history, all this history. And one of the things that she did with one of her research assistants was to read Justice Alito's opinion when it dropped in draft. You'll remember that the Dobbs opinion was leaked in draft. And I don't know about you, but that moment was extremely significant, terribly painful. I think all of us knew that Roe was, you know, on its deathbed, if you will. It felt much worse when the actual opinion was announced, but we knew for many weeks that this was coming. So one of the things that Bonnie did was to take the draft and to evaluate it closely as if it were a draft paper that had been submitted to her by a student. You know, a PhD student and a smart undergraduate. And what they do is they go through it and they point out the numerous problems with the history that Justice Alito relies on. And one that I find really interesting, again, he looks back to history, including some 13th century sources. And here's the the 13th century text looks like. And the problem, of course, is that it's a manuscript, which means it was written by many people. I mean, I can't read it. I don't even know what language it's in. Sorry. But what Bonnie would say to you is, in order to understand, like, the first question is, why are we looking to a 13th century text to determine the rights of women in 2022? But even if that were a sensible inquiry, the problem is a manuscript has been written by many people. You have to be an expert in terms of interpreting the meaning of the manuscript. And one of the deepest problems and we know that the justices did not read this manuscript themselves. They relied on somebody who translated it. And so you need to inquire about the translator's skill. But the other problem with it is are questions such as these. It's true that there are many references to abortion being a crime, but we're not at all sure what those sources mean by the word abortion. Do you see what I mean? So they would use the word abortion sometimes to describe something totally different, something such as miscarriage by assault, for example. So that's one thing. We just have no idea whether they were using abortion in the way we were using abortion. And the other thing too, of course, is that the line between crime, what counts as a crime, and what doesn't count as a crime then, depended not on what we would think of as civil law decisions, but it was a religious question. So a lot of these texts are infused, as you would understand, with religious meaning and religion assertions that are founded on religion. So, it's very hard to know when they say abortion was a crime, what did they mean exactly? And by both abortion and by crime. And then, of course, part of the problem, too, is that they're relying on texts that were written before doctors, let's call them that, had any clue as to how babies were made. Like, everybody knew that people had sex and eventually a baby came along. But as Bonnie has taught me, and I need to do more reading about this, is that they had no idea about sperm and eggs and conception. I mean, they were just completely in the dark about what today we would call, reproductive science. So their grasp on reproduction, on how it worked, all of that was extremely dim, and it's just really troubling to be relying on these documents. At that time as well, women were considered mysterious. Their bodies were this sort of strange terrain. We frequently were compared to dogs, that both women and dogs go into heat and so on and so forth. Just all kinds of strange, we would think, mistakes that they believed were true. The other thing, of course, is that one of the sources on which Justice Alito relies heavily, the author of that source believed that women should be executed for witchcraft. And then the document I showed you, I think this is where Bonnie would be better. I think that the author of this document was writing at a time when you discovered if women were virgins by placing them on a head of garlic and then smelling their breath, and that would tell you. So, I mean, these are so antiquated in terms of thinking about the underlying activity that we're talking about. It's almost impossible to think that we could read this opinion with a straight face and say, okay, jurists who thought we should be executed for witchcraft are now determining the meaning of liberty for women in 2022. So if Bonnie were here, she would give you a much more fulsome and more lively description of that history. And hopefully we can bring her back at another time, or you'll reach out to her with your thoughts. And so once you do that, of course, everybody agrees, okay, abortion was a crime. I mean, the dissent agrees abortion was a crime, or was a crime in some places, or there was some understanding that some activity that we might call abortion was criminalized. But what the dissent says, again, as I mentioned, is liberty. The framers use that general and that broad conception deliberately in order to give us the ability to think about liberty in its fulsome way, not in a narrow, specific way. Did the framers think we had the liberty to do this? But what did they think liberty required for us to flourish? And so the dissent, of course, looks to very different sources, including the evolving understandings about the importance of women as full human beings. At the time of the ratification, women were not regarded as full human beings. Coverture, the law of marriage, where the woman is absorbed into her husband, you lose your legal identity, right, at that point. So, all of that, all of that history is obviously history that's incredibly important. Likewise, at the time of the ratification, no one would have thought that Brown v. Board of Education was a thing. Equality meant separate but equal. So likewise, miscegenation. It was not thought that miscegenation was a violation of equality principles. African-American people, again, 14th Amendment is part of the Reconstruction Amendments, but the African-American people, formerly enslaved people, Native Americans, they are not part of the people who ratify, the group who are thought to be the founders who ratified. We just are simply not part of that discussion. And so it's quite, it's, to be candid with you, absolutely terrifying if we are really bound by that history, what that means for the full personhood of people of color, of Native Americans, of LGBTQ people, of women, and so forth. So that's what, again, the dissent wants to say is we need to, and the framers wanted us to look to more contemporary traditions. Otherwise, the Constitution is broken, is not going to endure. So I think I want to say a couple of more things about these decisions. One thing that's been absolutely devastating, it was devastating when Dobbs dropped, but it's even more upsetting now. And I take it the court doesn't care. So, I just have to sort of acknowledge that. But one of the big questions for the court in Dobbs is highlighted by Chief Justice Roberts in his concurring opinion. He doesn't join the court's opinion. He writes his own concurring opinion. Basically, he says, look, we don't need to overrule Roe and Casey in order to uphold the law that's in front of us here, right? The Mississippi law, we can uphold this restrictive law because we have the power to do that. Casey, we can talk about Roe and Casey if you want, and what the lay of the land looked like. But what he said is, look, we as judges have no authority to overrule a case, a particular case that's important, unless we must, unless we have to. And this case does not require us to. This case does not ban abortions outright. It provides another restriction, a timing restriction, but we're able to uphold that statute, and we should leave for another day the question of whether we overrule Roe and Casey. And one of the things he points out to us all is people have relied on Roe and Casey. People are out in the world and they have relied on these decisions, and they've relied on them when they're arranging their day-to-day lives. People are making plans about their lives based on these decisions. And so he's taking the reliance interests, and he's very worried about the court's legitimacy, as he should be, right? He absolutely should be. You should hear what some of my first-year students have to say about the Supreme Court after looking at this decision. So that's what he says. And Alito, in his very lengthy opinion, doesn't ignore this point. He talks about the reliance interests, and he agrees. He says usually or always, when we're considering whether to overrule a precedent, one of the issues we need to think about is, have people relied on it? It's important that the law be settled for a lot of reasons, but one thing is, if the law keeps flipping and flopping, you can't go about your daily lives. You need to have some reassurance. And so what he says is, I just have to read the language to you. He says traditional reliance interests arise when advanced planning of great precision is most obviously a necessity. Okay, so he agrees. reliance interests are implicated where there's advanced planning at stake. And what he says is these reliance interests are not implicated here because getting an abortion is generally an unplanned activity, and reproductive planning could take virtually immediate account of any sudden restoration of state authority to ban abortions. Just let that sink in light of what we're seeing. Abortion is unplanned, so you're not relying on the fact that you can get one in ordering your activity. I don't know about that. But then he says reproductive planning could take virtually immediate account. People who are planning their reproductive lives can take immediate account of any sudden restoration of state authority to ban abortions. And, like every now and then, like in my waking hours in the middle of the night, I think, well, are they reading the papers? Do they see the tsunami of trouble, the tsunami of people whose lives have been upended, have been disturbed, and I mean, people are going to die, and then I think they just didn't care. I mean, that's all they have to say about it. It's a kind of callousness that is, I think, breathtaking. And I've read a lot of callous decisions in my time. A couple more quick things, and then we'll turn to questions. And I really am grateful to you for listening to so much. But I think this tees you up to now talk about it. To talk about why it was that Chief Justice Roberts said we shouldn't do this. If we do, we're going to lose the legitimacy that we enjoy as an institution. As a court, we don't do more work than we need to do, and we do not need to take this fateful step in order to resolve this case. Majority just blows that off. So the other thing is, like, what about abortion restrictions now? Like, what happens if for some reason a state passes an abortion restriction and someone decides that they're going to challenge that restriction in federal court? And I think that the answer is pretty clear, that the federal courts are the doors are closed. And what the court says is, because you don't have a fundamental liberty interest in reproductive care. Previously, we had a fundamental interest in reproductive care. This is something that I should have set up before. But once the court finds a fundamental interest in reproductive care, then it will examine the state restriction very strictly. It's called strict scrutiny. So if you have a state law that impinges upon a fundamental right, the court is going to take a really hard look at that restriction and require the state to give powerful reasons for doing it. You've got to explain why it is, for example, that you are discriminating because of sex. You've got to show why you're discriminating, and basically, once you have a fundamental interest, such as preventing race discrimination or protecting First Amendment rights or these liberty interests, the states usually cannot satisfy their burden of justification. Here, what the court says is that abortion no longer enjoys that protected status. So all the states need to do now, if their laws are challenged on federal constitutional grounds, is to show that their laws have what's known as a rational basis. And this is the language that I find quite striking and important. I'm just, as you're thinking about strategies, like, where are you going to go? You're going to go to federal court? The court says a law regulating abortion, like other health and welfare laws, is entitled to a strong presumption of validity. Right? Strong presumption of validity. And the court then goes on and talks about the fact that the legitimate interests that the state has in this area include respect for and preservation of prenatal life at all stages of development. So the federal courts are now to approach abortion restrictions, giving them a strong presumption of validity, and it is legitimate for the states to pass laws with the aim of preserving prenatal life at all stages of legitimacy. So this is why, again, reading the case makes us think that we need you all, right? We need Charlottesville now. We need our state workers, our local folk, because going into federal court is not going to be useful, possibly for many generations, when you think about the age of the justices who were put on the court precisely for the reason of overruling Roe and overruling Casey. Very quickly, and now I will stop. Oh, I'm seeing Wendy Murphy in the chat. So you're exactly right to suggest that Roe is not a perfect case. Roe uses the word privacy. Roe talks about it finds in the due process clause and in other parts of the Constitution, including the Fourth Amendment, a right to privacy. And that made a lot of people criticize the Roe court because privacy is not mentioned anywhere in the Constitution. And so everybody said, oh my gosh, the justices are making up a right to privacy. And there's something to that criticism. And in Casey, the court goes out of its way to make clear that it's not a privacy rationale, but a liberty rationale. But if you think back to the definition of liberty, of substantive due process liberty that I gave you, you can see why the word privacy is really just a description of the liberty. The notion is there's some stuff in the world. Who are you going to have sex with? Who are you going to marry as an adult? Are you going to use contraception and so forth? There are some decisions that you're entitled to make free of government oversight, regulation, surveillance. They're private in that sense that we want the government to stay out. So it's a liberty interest in allowing us to make our own decisions free of state coercion. So yeah, I agree. The word privacy was not a great word, but there's ways to explain, and the court does that in case he puts the Roe right on a much firmer constitutional ground. So quickly, and then I will stop. What happens now? Like I said, we see this tsunami of questions that are coming our way as the states, many states, a number of states are proceeding to pass highly restrictive abortion laws. We're told that our own governor has that as part of his agenda. And I'm teaching a short course with Bonnie and somebody, another law professor, Naomi Khan, here at the law school, in which we're trying to collect some of the issues that might come up, spending time with experts around our own community, people who know better than us what the world should look like. But and there's just so many questions. I mean, the weight of fear, anxiety, anger, from dread from the medical side, from OBGYN folks. Maybe some of you are doing that work, have friends, family that do that work. It's extremely heavy. The sense of emergency that I have as a lawyer, like, can I write a statute? Can I bring a case? You know, that's nothing compared to a doctor who is trying to decide whether the exception to protect the life of the mother extends to this patient, or whether he has to wait a little bit longer before he can intervene. I mean, I'm sorry, I'm going to tear up. When I had those initial conversations with our OBGYN folks at UVA, I just thought, oh my goodness. As a lawyer, I don't understand what emergency means exactly. I'm a law professor. But the other question is, what are the implications of Dobbs for other fundamental liberty interests that the court recognized as part of the Roe-Casey stream of cases? So in his concurring opinion, Justice Alito takes pains. He lays out very clearly, as I said at the beginning, he does not believe that there is such a thing as substantive due process. He does not believe that the substantive due process line of cases were correctly decided. And so what he says is, look, the same reasoning that is leading us today correctly to overrule Roe and Casey will also lead him, and one has to assume other justices, to overrule the contraception cases, to overrule the same-sex marriage cases, and to overrule Lawrence versus Texas, which is the case that forbids the state to punish people for having sex, for having same-sex sex or sex. So he makes it clear Griswold is up for grabs, Obergefell is up for grabs, and so too is Lawrence. And so he, in effect, is inviting the states to go ahead and to ban gay marriage, to go ahead and ban contraception, and to once again punish sodomy. There's a bunch of laws that we need to look into, Lisa and Charlotte. What do our statutes currently say about that? And I fear that there are states that are poised to take him up on his promise that he is willing to consider the legitimacy of those rights. I talked about this issue with my students in crim law. I was hoping to hear whether they thought that we could distinguish, let's say, the contraception cases, whether we could distinguish the marriage equality cases from Dobbs, and they were at a loss. I was hoping they would give me something, but they didn't. So there's a good bit more to say. Justice Kavanaugh has a concurring opinion in which he goes, oh, look, Justice Thomas, saying what he's saying, but don't worry, we are going to be able to distinguish Dobbs from, or we're going to be able to distinguish abortion from these other cases. This does not, mean that we're on the verge of overruling all of these fundamental rights. And he sort of, so if you take his word for it, maybe we're okay. But it's going to take a long time to figure that out. And in the meantime, many people may be harmed if the states take action to outlaw their identities and their intimate activities. So I think I should stop now and take questions. You've been very patient, and I'm intensely grateful for it.
Excellent. Thank you so much, Anne. This has been so truly informative. I wanted to highlight a few things in the chat, but also mention that I recently learned about the longest serving associate justice in American history, who was known as Wild Bill. They had some other untoward names for him as well, such as Poophead, but I won't use the other word. And that he was in his 70s, married 4 times, and sort of wrote this idea, of privacy, abortion and privacy, into the penumbras or the hidden shadows of the Constitution, because he was a skirt chaser and he really wanted to protect himself. So I just thought that was sort of worth raising up, that overt sexism and why we might have privacy. And I thought maybe you could say more about that before I get to something I'm very proud of, Virginia being the 38th and final state to become, to ratify the Equal Rights Amendment. So I want to move to that after I give you a chance to comment.
Yeah, so the thing you need to know, though, is that Justice Blackmun, who is a very straight-laced kind of guy and a big surprise to everybody, is the author of Roe. And it's true that Justice Douglas and others were in favor of the privacy rationale. And you're absolutely right. It rests on penumbras of the Constitution. And, that's not going to satisfy anybody when you start talking about penumbras. And I think but it's Justice Blackmun who ultimately writes Roe. And, he's been heavily criticized for this viability structure and the 3-trimester structure. But when you talk to anybody who works in that world, they all agree it worked pretty well. Viability, it's true that viability has been a moving date. Viability occurs earlier in time now that we have better medical care. But everybody agrees it's around 20, 22 weeks, or, around in there. And so the viability framework has worked pretty well. I think the larger point you're making is so fascinating, and we ended up talking about it, and we'll talk about it in our class, is this privacy rationale. You're exactly right, is very problematic, because it's within privacy that women have been harmed, right? This is a private matter. You shouldn't be talking about this. Well, why not? Because it's shameful. You've got to keep this to yourself. And so and certainly that was the generation that I grew up in. I tell my students that I could never have gone to my parents and told them I was raped, because they would have been angry at the thought that I had had sex. So you can just forget about the abortion thing, right? I mean, it was just like, you couldn't even, my parents are good people, and my father's still alive, and he's changed his views, which is great. But when I was a kid growing up in a Catholic community, I mean, this was private in the sense that it was secret, and it was private because it was stigmatized and it was shameful. And so today we're seeing some rejuvenation of privacy arguments. And so, for example, we're being told, don't use a pregnancy tracker anymore. And that's probably, a period tracker and a period app. And some of my students, a whole bunch of them have told me they've deleted their apps. And some of them are tracking their periods because they have serious health problems. They're not tracking it for pregnancy purposes, but because they have underlying health issues. And suddenly, I'm like, oh my gosh, you're putting yourself in harm's way. Your health matters the most. And they're talking about whether they should write it in a diary, but the fear of having the police surveillance, because we've unleashed this surveillance. But one of the things that was interesting to me as their, I could be their grandma, as I tell them, we were just coming to a place where we were starting to talk about this stuff. Women of my generation were being encouraged to tell our abortion stories and our grandmother's abortion stories, and to take this stuff out into the light and make it clear that it's just a normal part of the reproductive continuum. Abortion is part of a much broader set of reproductive decisions, and many, many women, for many different reasons, end up seeking and needing abortion care. And last year in my feminist theory class was the first time a young woman ever shared an abortion story. And I actually felt, this was before Dobbs, I actually thought, wow, we're really coming to a new generation where people, they're able to normalize this. And suddenly we're being told we've got to pass statutes to make all this stuff private. And I agree, it should be private in the sense that it's nobody's business but our own. The state can't, use surveillance and coercion of our reproductive rights. But the problem again is that privacy is a double-edged thing, because it rests on ideas about women being shamed, women being stigmatized. So here's a change you need to make in the Virginia Code. It refers to the harm that rape inflicts as defilement. Rape is a defilement of women. And I'm like, no, it's not. Rape is an injury. It does a lot of things to us, but it does not defile us. It does not spoil our chastity and make us toxic, poisonous, unmarriageable, whatever the word defilement means. And I've talked to the legislature, Lisa and Charlotte, or I've talked to legislators who said to me, oh, Anne, that's just language in the statute. And I'm like, that's the law.
Words matter.
So it matters, but you're exactly right. The privacy rubric was thinly theorized. We fear that it was protecting the interests of men far more than women. And it's a double-edged thing. Yeah.
Yeah, well, thanks. So Wendy has also put in the chat, and I'm eager to hear your answer on this. The dissent was embarrassingly incorrect on the issue of women's equality. They described the history, but utterly failed to point out that women are still not equal under the Constitution, and that this lack of equality enabled the majority to overturn Roe. The ERA affords us the opportunity to reboot the Constitution and consider anew under the ERA a host of good new arguments for why abortion is clearly protected in the Constitution. And I'll just say, talking about rape and defilement, and as a survivor, it is the most unreported crime in America for a reason. So yeah, if you could say more about that, which I believe ERA would protect survivors as well.
Yeah, so I really agree about the ERA, and again, very fair point about the dissent and its history. I'm not sure why it omits any discussion of the ERA, but lawyers, I hope I mentioned this at the beginning. One of the reasons why I was so happy to have Bonnie here is because lawyers are rotten historians. I mean, we're not trained. We have no historical chops. We don't know what we're doing. And yet we rely on it all the time. And suddenly we have a constitutional methodology that depends on historical arguments. And so you really need to be learned in that way, or relying on sources that are learned. And I don't know why the dissent doesn't delve more into the discussion of the ERA. You know, one of the things that's really fascinating, this is a little sidelight, but I attended a Zoom panel maybe a year and a half ago. It was about constitutional law. And one of the presenters was a woman who pointed out that when we teach common law, we never speak about the suffrage amendment. Like, when we teach common law, we teach all of this stuff, like about the dormant commerce clause, like, and the students are like, snoozing. I mean, and they need to know it, but like one of the most significant constitutional amendments in our history, giving women this access to the vote, to allegedly to full citizenship, it doesn't even get discussed. And I was like, oh, so there you go. There's the absence of voices of stories about women. So yeah, so the dissent, it's interesting to remark though what the majority says about equality, because the equality argument is there, and the majority gives it the back of its hand. It says, look, these abortion restrictions don't present any equality argument whatsoever, period, full stop, because only women can get abortions. And so there's no discrimination. Do you see what I mean? There is no sex discrimination, because we're talking about a procedure that only women ever need or seek access to. So equality is not even part of the discussion. So they're not interested in thinking again about equality more broadly. What does equality mean? Even under that very cramped view of equality, you can say, well, it's true that men don't need access to abortion care, but notice we don't require men to give their kidneys to their son. We don't require men to give up their body, or to have parts of their body used to benefit another person. You could I mean, I'm not saying this will be a winner. Justice Alito is not going to go for that argument either, but you just see the very cramped argument. As long as this is a restriction that applies to women only, there's no control group of men. Well, it's just not an issue. So they just absolutely give it the back of their hand. And the dissent, does a pretty good job of talking about, our students discuss the fact that in the majority's decision, potentially pregnant people don't appear at all. They're not there. They don't exist. There's nothing about their embodiment, their experience, just like, oh, well, if the laws change, you can quickly make alternative arrangements. At least for the dissent, there is discussion about the impact of the loss of this right on women's futures, on young women's futures, on all potentially pregnant people and their ability to plan their lives. And the particular concern we're focusing on now is the impact on women of color and poor women. Those folks will be the ones who bear the burden of the police surveillance. It's already happening. So there's, the dissent at least focuses us on those things. Rotten history, yeah, welcome to my world. Yeah.
Seems like we have a problem with the denotation as well as the connotation of the terms liberty, freedom, equality. Yet we talk a lot about those in our loftiness, right? Yeah. Are there questions? Other questions folks are interested in? Let me catch up here in the chat. Do folks have any questions? Please put those in the chat. And we'd be happy to
what I would say about the ERA is I agree. I think it's massively important. And one of my colleagues who I really treasure, he was sounding a cautious note about the ERA. He said that he thought that women might be in a better position without it because the Supreme Court has construed the equal protection provision, which clearly applies to African Americans, in such a way as to prevent any use of race to benefit African Americans. So, this is the affirmative action debate, right? So now we're race blind and we can't discriminate against anyone. And that means that if you have a law that is trying to make reparations for the history of slavery and all of the Jim Crow era and everything else that followed, oh no, you're discriminating against white people. So there's been this very artificial sort of race blindness doctrine. And the court has been less strict on that front when it comes to gender discrimination. So in VMI, Justice Ginsburg, who's the author of VMI, said something like, oh, well, we don't use the strictest scrutiny and there's still room for some laws that are designed to benefit women. And I read that stuff and I thought, oh man, you shouldn't be publishing, these arguments against the Equal Protection Clause, or I'm sorry, the Equal Rights Amendment. It really bothered me. I mean, you need to have this constitutional flag, right? And for so many reasons. And then along comes Dobbs, and I haven't had the heart to reach out to him and say, what do you think now? But I agree. I've seen some of that go by. Anyway, I'll stop.
Yeah, no, this is wonderful. And Roberta, you have a question. Your hand is up and I've unmuted you. Go right ahead.
Yeah, I did put up my hand. I didn't know if you wanted to take verbal interchanges here or not, but thanks a lot, Lisa. And great program. Thank you very much. I'm the ERA Education Coordinator for the Alice Paul Institute. I've worked in the ERA for 45 years and counting, almost half the 99 years it's been out there. But this was so great, Anne, and I wanted to pick up on one or two things. One, first of all, many minutes ago, you had said, I wrote down, it was a super sentence about a more inclusive reading of the substantive issue around liberty, 14th Amendment protection of liberty. And you said there's a core to liberty that the state cannot intrude into by this reading of it. And that, to me, is what right to privacy is, literally. So I think we say it's just the penumbra of a penumbra. No, damn it, it's just a more inclusive reading of the 14th Amendment. There were different constitutional law philosophies, and the boys in charge now are originalists. They have the conservative reading, but where, except for the number of votes they have on the court, is there credibility? This is a more just a academic question. Is there credibility really to the originalists going back and saying, we're only going to interpret it when women had no legal rights, married women had no legal rights at all? That's what we're basing our interpretation of the Constitution on in 2022. I mean, how can somebody defend that with a straight face? I ask rhetorically. But the other thing I wanted to mention, I did put in the chat, Alice Paul Institute has www.equalrightsamendment.org website. There's an FAQ page on that I just updated. It's only a couple weeks fresh now. And I highly recommend anybody who's interested to go to that, because a lot of these points, even like what you were saying about the person who just published, don't worry, maybe you should be worried about the ERA. No, when you look at the precedent for that, BMI and so on, the precedent is you can differentiate between male and female as a class if it's to remedy past discrimination. Now, if you have a court that's going to be so awful, they'll say no to that, then, the water is hotter that we're in than we realized. And the last thing I wanted to promote is there's a book that was published just last year called Gendered Citizenship, about the Equal Rights Amendment by Rebecca DeWolf. It is fabulous. The whole idea of gendered citizenship is what we're living under now, when there can be an interpretation of women's citizenship that allows the state to say, no, you don't have autonomy over your body, but a man does. He doesn't have to donate his kidney. And the Equal Rights Amendment, equality of rights shall not be denied on account of sex, does away with gendered citizenship. And to me, if there's any one sentence here, let's start the discussion here. It is to say, we're still living under gendered citizenship, and we've got to get the ERA and the Constitution to do away with that. So that to me is, there can't be any argument against the ERA that doesn't pardon the word Trump that. So anyway, thanks. I just find this was fascinating. Thank you so much.
Yeah, I'll just follow quickly. I mean, thank you so much. Your elucidation of these points is so clear and so helpful. And I'm glad that what I said resonated with you. And I'm especially glad to hear your observation about privacy. It is describing a kind of liberty, just using that word.
Yeah.
You tweak it ever so slightly, and it's just that there's some stuff, it's private in that sense, that we should be left to do it by, without the government telling us. We can turn to our friends and family or whatever, but the government just simply cannot coerce or step into certain kinds of decisions. And that's liberty, I think. And I'll visit the ER page that you recommended, and I'm certainly going to recommend it to my students. Again, the youngsters, I think, again, they're our hope, right? And I think that there's just a tremendous amount of energy and well, there's a lot of despair. I'm seeing that as well. People are just very tired and they feel heavily the loss of the rights. So one of the things that I find fascinating is when the court is talking about these reliance interests and how we don't need to worry about reliance interests because I don't know, I don't know what you can do, but it's no big deal, right? Just use birth control the next time, I guess is what they're saying, or something like that.
Just don't get raped.
Yeah, exactly. Oh, well, but there's my other thing for Charlotte and Lisa. We have to work on the definition of rape in the statute. But
1000%.
so yeah, so I think that what's missing from contemporary discourse, and this is because we've sort of commodified everything, and and the lack of embodiment in the opinion, the fear, the anger, the anxiety, the anguish. I mean, and I'm actually talking about an embodied feeling that so many women, all of my friends had for days, male colleagues coming up and telling me that their spouses, their wives were despondent and wanted them, the spouse, to do something about it. You're a law professor. You can fix this. And they would come to me and they'd say, Ann, I can't do anything. I mean, these are good people, but I was just like, oh, so the court doesn't talk about that what it's like, the shock of relying on at least what you felt was full citizenship, right? Was a marker of respect. And that's suddenly being taken away from you. I really struggled with that and continue to, particularly as I look at young women, and I know that I'm going to leave the planet and they still are going to be living under this regime. So that's tough. The other thing, Roberta, is, yeah, there are people in the legal academy who with a straight face will absolutely defend what Justice Alito did. I mean, we at the law school have one of the largest Federalist Society student chapters in the country. They are very active, and they are, I assume, rejoicing. I think you said something about talking to them with a straight face, and just lately I've bounced back enough to be able to start talking to people again. But
Thank you, Koch brothers.
Yeah, I just fear the conversation. So I've avoided them. But yeah, there are many folks out there who think that this is an appropriate methodology, and I think who are waiting to see, for example, gay marriage struck down, or whatever it is that the states might get up to. So yeah, it's really, yeah.
And I hate to add this wrench in there, but part of the problem here too is we need to end and overturn Citizens United, because all of this dark money in politics is influencing, in particular, women's rights and LGBTQIA rights. I hope you went on mute, Anne. I need to.
The cruelty of the opinion. So Alito, as I mentioned to the group at the beginning, mentions that he says women are not without. They always love the double negatives. Women are not without electoral or political power. And I thought, yeah, that's true. And that's what they're saying is, look, we're just telling you to go to the people, go to the democratically elected representatives. But when that's coming from a court that has simultaneously gutted voting rights, has made it made it very easy for they refuse to regulate gerrymandering. They are cutting back on the civil rights laws that protect people of color's access to the ballot. So the idea that, suddenly this is going to be, easy as an electoral matter in light of the cases, you mentioned the money, the dark money, it's just the cruelty of it is just breathtaking. Yeah, I've got to come to a hopeful note with you all. And I'm not really sure how to do that now. I've just talked myself back into a dark place. But I think the hope that we have is that we can work together at the local level. We can take joy and comfort and love in each other's company and spend time together and work together. There are people out there who are prepared to be arrested in order to defend these rights, but the arrests they're facing are not just trivial arrests for misdemeanor trespass or something. They're potentially very serious, and that is not something that I think many of us can or should be prepared to do. We have a lot of things we need to do, but we can work together. There's a lot of work to be done in Virginia to keep Virginia a safe state, a haven state, and that's my objective currently. Yeah.
And then who we get on our benches, right, across the state really matters tons. Who is elected or to be a judge by our General Assembly.
Absolutely.
We need more women. We need more women of color.
Yeah.
So
yeah. The ACLU is working, I'm told, or thinking about working on a constitutional amendment for the Virginia Constitution. I don't know how long that would take, how that would go.
So that's about 4 or 5 years away. We're all part of an equity alliance, 16 groups called the Virginia Reproductive Equity Alliance, which includes Virginia Now and all its affiliated chapters, ACLU, Repro Rising, Planned Parenthood of Virginia, the Blue Ridge Abortion Fund, and others. So we are working and talking about language to a constitutional amendment, and it might be great to have some input from some of the law professors at UVA on that language. So would love to invite you to that table as well. Definitely. Are there any other questions that I may have missed, or anybody that would like to unmute themselves in the 6 minutes we have remaining to either make a point or ask a question? Peg, I see your hand is up. I'm going to send you a note and let you unmute. Hold on 1 second. There you go.
I'm concerned about some of the peripheral issues on these state laws. For example, citizens testifying against each other, getting bounties for testifying against women who are getting abortions or even thinking about it, and the tendency for states to start to penalize women who live in their states who go to other states where abortion is legal. Are those things possible? I mean, are we at least able to fight those kinds of elements of anti-women legislation?
So Peg, one of the things that I have to say to you right now is that we don't know the answers to the questions you're asking. So the interstate travel question is absolutely compelling. We are bringing women to Charlottesville, to other places in Virginia, to clinics, and we've been doing this for a long time. And when I say we, I mean our local abortion, our community providers, our abortion funds has been bringing women here, and more, right? And then women from Virginia are traveling to other states, and God knows that could be something that we have to do. So we don't know how that's going to work. We're waiting to see. There are some states that are apparently moving aggressively to try to assert that they have the authority to punish people who have abortions out of state. They're trying to prevent people from getting, medication abortions, and so on and so forth. And we just don't know the answers to these questions, and it's going to take a long time to figure it out. Again, going back to Justice Kavanaugh's concurring opinion, where he says, don't worry about it. We're going to be able to distinguish Dobbs and abortion care from these other fundamental rights. He also throws out the suggestion that we don't need to worry about the interstate travel, the traveling questions. He says you don't have to worry about whether you can travel from Texas or Florida, say, to Virginia, because the Constitution protects an interstate right to travel. That is absolute hogwash. There is no such constitutional right. The court has never recognized such a constitutional right. They have hinted at various times that we might have one, but that is a huge open question. And so the point is, even if it were resolved favorably, think of what's going to happen in the meantime. It's going to take a long time for that question to get to the court. And then Lord knows if Kavanaugh will actually hold to what he says, because why should he? And then of course, we don't know that he would have a majority of the court. So, you know, I think people were protesting when he was out for dinner once, and one of the satirists in the New Yorker, I think it was, who I love, you know, was saying something about a constitutional right to have dinner, you know, like free of abortion protesters, because, you know, Kavanaugh was complaining about this, you know, comparing that interest to the interstate travel analysis. But I mean, so yeah, my response to you is the terror that we have as lawyers, where we have people in the room, such as y'all, such as our students, and we don't know the answers, right? We don't know. And so people have said to me, oh, don't worry, for example, about all these questions about whether they're going to outlaw gay marriage. Don't worry about them outlawing contraception. There'll be no political will for that. They're never going to do it. And I'm like, yeah, they are. They are. And so, and then people say, oh, well, don't worry, the court will distinguish, you know, contraception or distinguish same-sex act. Like, maybe, but maybe not. So we don't know the answers to this. And it's absolutely terrifying. And this is why, of course, you talk about the chilling effect for doctors. I mean, there are folks who are absolute, and not to here I keep talking about the professionals. You know, what about the youngster? What about the middle-aged woman? What about the people whose lives are at stake? And suddenly they don't know what they can do, right? And the harm and the fear and the pain. You know, I bring up the doctors because their emergencies are closer to the people on the ground. But people, you know, suddenly, so we don't know the answers, but a lot of people are going to suffer in the meantime. So we really need to work together and figure out a way forward.
More op-eds, defining equality and what that means, right? Defining freedom, defining liberty, and teaching in law schools. But I understand funding might prevent some of the honest teaching.
Well, there are folks in those states who are desperately trying to leave their institutions. You know, I mean, again, I'm just reporting to you what I hear through the quiet grapevine,
Right.
you know, and I'm not sure how widespread the fear is yet. But I mean, I've had students tell me that they have friends, for example, who are just starting at the University of Texas, you know, as law, and are just desperate to leave, right? To go, you know, can I transfer? And the same thing with faculty as well. And the chilling, you know, on speech about all of this, because something like, are you aiding and abetting if you give to an abortion fund? Are you aiding and abetting if you share, you know? And of course, you all probably know the folks who run our local abortion funds. They're heroes and they are worried. They are stalwart, and we have to be there to catch them and not even let them begin to tip over. But it's absolutely terrifying. So the last quick thing I'll mention, I can't resist, is one thing that has been of some weird kind of comfort is that every now and then one of the very restrictive states will say, we're a very restrictive state, but we will have an exception for the woman's health, life, and we will also have an exception if you've been raped or the victim of incest. And of course, we don't know what threats to the woman's health are going to suffice. This is the problem that doctors confront. They're so terrified they're going to be second guessed about whether it was sufficiently imminent threat. But the other question is, what counts as rape for purposes of this exception? We have absolutely no idea. And I was talking to a journalist about it the other day who's starting to dig into the question. Does rape require a conviction of the perpetrator? Clearly not. Otherwise, the exception is meaningless. But does it require the filing of a police report, the taking of a rape kit? Who decides whether rape, however it's defined, occurs, right? And then the problem is, how does the state define rape to begin with? So New Jersey has a very protective, I don't know how if it works in practice. None of this works really well in practice, but in New Jersey, a rape occurs if a partner fails to get affirmative permission. If you proceed to have sex from someone in the absence of affirmative permission, right? That's a rape. That's a yes means yes rule. Well, in Virginia, we require force, threat, or intimidation. So you have to have non-consensual sex, but it's not enough that the sex be non-consensual. We don't punish people on a no means no basis. We don't punish non-consensual sex. We punish it only if it's non-consensual and there was force, threat, or intimidation. Yes, I have looked into this. Yes, my students have looked at all the cases. Yes, we have tried to talk to legislators. No, we have gotten nowhere because they keep saying, oh, Anne, the cases you're worried about, that's just language. No, and like they're wrong. They're just wrong. I mean, it is language, but it's the law. And there are cases that suggest that even though so few cases are prosecuted, this is a concern. So this is where I'm worried if Youngkin is going, if he's going to pass a restrictive law that says, you know, a 15-week rule or whatever it would be, maybe after that he'll have this exception. And again, if you're like me, I think, oh, well, at least we've got the exception. I teach criminal law, you all. I have no idea how the exception would work in practice. And it doesn't work. It doesn't work. It can't possibly work. And then, of course, you're adding, this goes back to, I'm looking around, I can't see, maybe. Oh, Roberta, I think, mentioning the privacy. And again, women are constantly faulted when they come forward and report a rape. You're lying. You made it up. You see what I mean? And this will be just another reason to say women are lying. And I don't have it in me to tell my students, oh, you have to report. You know, they don't want to go to the police. They know it's not going to make any difference, right? I mean, I encourage people to report, but you get my point? Like, so what's Lindsey Graham? Like, does his bill have a rape exception? Talk about federalism concerns, right? I thought we were going to leave this to the states. Oh, no. But in any event, I need to look into that and to see, because if you have a federal law that gives a rape exception, well, what does rape mean?
And we're also talking about physical health, but what about mental health to the women? Right? That's a whole nother thing.
I don't know if it's covered. I don't know.
And mental health to their livelihoods in terms of their ability to build wealth. What does that mean for their employment and all the rest?
The latter part isn't going to count, but yeah, that's the question. And I don't know if you all have watched the documentary, The Janes. It's really fascinating. It's about a collective of women prior to Roe v. Wade who banded together to help women get abortions. It's really powerful stuff. I have another movie recommendation if anybody wants to hear it. But anyway, one of the things that's fascinating there is to see how that exception, sympathetic doctors that would use that exception and to, if a woman would certify, or I don't know, certify is the wrong word, like how do you have to make this statement, would say, I'm going to commit suicide.
Right.
The doctor would then say, okay, there's a threat to your life. The pregnancy poses a threat, not just to your mental health, but to your life. So those kinds of subterfuges were being used. That's why you've got to watch The Janes. It's pre-Roe. It's pre-Roe v. Wade. That's where we are.
Turning the clock back.
Yep. All right, now I stop.
Right, well, thank you. I just want to, before we end the recording, thank you, Anne, and thank you, Bonnie. Maybe we'll get her back for another session with you, color commentating. But thank you, everybody, for participating. Thank you, everybody, for coming. We're going to stop the recording now, and we do have some time for those that want to stay in the Zoom room to have a bit of an after chat with Anne if she's willing.